Rule of Law for Muhammad Roziman bin Saidun versus Public Prosecutor Case, Article 7(1) of Federal Constitution, protection against retrospective criminal laws and repeated trials. No person shall be punished for an act or omission which was not punishable by law when it was done or made, and no person shall suffer greater punishment for an offence that was prescribed by Section 15(1)(1) DDA 1952. Section 15 Self-Administration. Any person who consumes, administers to himself or suffers any other person to Section 14 to administer to him any danger specified in Parts 111 and 4 of the Schedule should be guilty of an offence against the Act and should be liable on conviction to a fine not exceeding 5,000 ringgit or to imprisonment for a term not exceeding 2. Section 31(1)(a) before amendment. When any person is arrested on the charge of committing an offence against the Act 31(1)(a) for the purpose of preservation of evidence, it shall be lawful for a police officer not below the rank of sergeant or an officer of customs to require an arrested person to provide a specimen of his urine for the purpose of an examination under subsection 1, if it is not practicable for the medical officer or the person who is acting in aid of or and the direction of a medical officer to obtain the specimen of the urine within a reasonable period. Section 31(a) 1AA after amendment, the Dangerous Drug Act or DDA 1952 Act 234, which is referred to as the principal act in this act, is amended in Section 31(a) by inserting after sub 1A for the following subsection. 1AA, any biological sample collected for the purposes of the examination under this section may be analysed by a science officer employed by the government.